They did. So what we did in Utah, based on that history, we passed a bill called House Bill 148, my bill, Transfer of Public Lands Act. You've all gone down that road, and some people say, well, we've already charged this hill. We've already charged this hill, why go there again? Well, there's some very substantial differences. Number one, we've never been in this economic situation before in the history of the world. We've never been here before. And at this time, because of that economic situation, this isn't just rural folks. This isn't just cowboys and ranchers coming in and saying, hey, you've got a sagebrush rebellion, they called it. Our teachers' associations were on board as we move forward on this bill. Our PTA, our school board, were supportive as we move forward on this legislation. Our Association of Counties, the National Association of Counties, has already done a resolution in support of this effort. So many others. Our access and open space groups were supportive. One of the things that we did in our bill that I think made a substantial difference. Well, let me just describe the bill. First of all, the fundamental basis for the legislation is based on a Supreme Court case, unanimous Supreme Court case from 2009. The case is called Hawaii versus the Office of Hawaiian Affairs. 2009, unanimous U.S. Supreme Court. In that case, let me take you back to 1893. In 1893, you had the Royal Hawaiians and the Native Hawaiians owning and governing the land in Hawaii, and industrial powers came in and overthrew them and took the land, seized the land and gave it to the federal government. Native Hawaiians were not happy. And they carped and griped and complained, and in 1959, when Hawaii was made a state, the federal government said, here, take all your land. Now, there had been an office established called the Office of Hawaiian Affairs, and the Office of Hawaiian Affairs looked out for the complaints that were still there from the Native Hawaiians. So Hawaii's made a state, and they say, take all your land. Well, in 1993, 100 years from overthrowing the Royal Hawaiians and the Native Hawaiian government and taking their land, Senator Inoue runs an apology resolution in Congress. And the apology resolution goes something like this. Whereas, now therefore, we apologize to the Native Hawaiians for what happened 100 years ago, and nothing in this resolution will deny or disparage any claims that the Native Hawaiians have against the federal government. Right? 1993. Fast forward a few years. Now the Hawaiian state government says, we're going to sell some of this land that was granted to us under our solemn compact, our solemn covenant, our sovereign act of statehood. We're going to take some of these lands and we're going to sell it. Office of Hawaiian Affairs comes in and says, hey, based on this subsequent act of Congress, you have to impress a lien on that land. You can't just sell it without putting a lien on that for the Native Hawaiians. And the state of Hawaii said, what are you talking about? Some subsequent act of Congress trying to change our sovereign act of statehood? And they go to Hawaii District Court, and the Hawaii District Court said, you've got no claim. They go to the Hawaii Supreme Court, and the Hawaii Supreme Court sided with the Native Hawaiians, the Office of Hawaiian Affairs, and said, you have to impress a lien upon all that land granted at statehood based on this subsequent act of Congress. Goes to the United States Supreme Court on that basis. The United States Supreme Court makes this statement in their holding. The consequences of a state's admission are instantaneous, and it ignores the uniquely sovereign character of that event to even suggest that somehow subsequent acts of Congress can diminish what was already bestowed at statehood. And then they said this proposition applies with even greater force where virtually all of a state's public lands are at stake. Think of what they said just a couple of years ago unanimously. Congress cannot enact some policy or legislation that unilaterally changes that sovereign act and commitment of statehood. Now, there are a number of other cases on the website. There are a number of other things out there. There are cases recent cases where the Supreme Court had actually cases subsequent to litigation that you had from actions that were taken in Nevada years ago, where they said that enabling acts are solemn compacts. They're bilateral agreements to be performed in a timely fashion. Well, what does that mean? A solemn compact is obviously something more than a run-to-the-mill contract. Again, it's an act of statehood, a uniquely sovereign character of statehood. So based on that, as a state, we set a deadline. I like to tell a little story about my daughter. She's up in college, up at Utah State. And she came home and she says, Dad, I got a problem. I buy food, I put it in the refrigerator, and my roommates eat it. And I buy more food, I put my name all over it, I put it in the refrigerator, and my roommates eat it. She says, what do I do? I said, well, honey, you got two choices to make. You can keep buying food and put it in the refrigerator, and your roommates will eat it. or you can sit down with them and have a really difficult conversation about what it means to be a partnership, what it means to be roommates in this system. What HB 148 does is we set a deadline, as we do when we have difficult things that we need to address, rather than letting delay and delay, as we've been dealing with so often. You fall back and delay and fall back and delay and fall back and delay becomes a tactic for one partner in a partnership that's out of balance. We said, no, there's a deadline. Now, we set a reasonable deadline of December 31st of 2014, that by that date we want to work with you, our federal governing partner, that you'll keep your promise, the same promise you already kept with all the states east of Colorado, the very same promise. We want to work with you on an orderly transfer so that we work this out in a manner that respects grazing and mining and open space and access and all of these rights on the land that have accrued over the 100+ years of our statehood, and not just throw those to the wind. That was something that in the Sagebrush Rebellion was maybe not as addressed perhaps as carefully. But we preserve those rights and carry those over status quo like they did in granting the land to Tennessee and Hawaii and Michigan. And then the lands are managed by Utah in a Utah Public Lands Commission by Utahns, for Utahns, and for our guests from around the world. And we set up a Public Lands Commission to do what was promised in the Federal Land Policy Management Act, but that was also failed. Federal Land Policy Management Act, right? After that 200 years of sacred trust history where the federal government only holds the land as a trustee to create new states, use the proceeds to pay the debt, not until 1976 did Congress unilaterally, on its own, without dealing with the states. By the way, in our enabling acts, it says this is an act irrevocable without the consent of Congress and the people. It says that right in the enabling act. Not until 1976 does Congress, with FLIPMA, say it's now our policy to retain these lands in federal ownership. You've got a policy versus a uniquely sovereign act. A policy versus a solemn covenant. A policy versus a sacred trust, the Supreme Court has called it. That question's never gone to the Supreme Court. Our Attorney General's office has been doing research all over. This has never gone to the Supreme Court. Can Congress, on its own, unilaterally, just change those solemn terms of that sovereign act of statehood? Now, we think the arguments on that, with all of the cases that go back, is clearly no. Clearly no. What's the remedy then? The remedy is more challenging. You can't simply go in and say, here's my bill for 140 years that you've not allowed us to tax the land to educate our children, that you've not allowed us to have the economic multiplier effect and unleash the ingenuity of Nevadans to develop our land responsibly